Fourth Amendment, search and seizure. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. Every parent that has had DCFS or CPS come and take their children with a removal order has violated your Fourth Amendment rights, because a removal order is not clear and convincing evidence. It is only a preponderance of evidence, and any judge that signs a removal order knowingly and willfully violates the constitutional rights of the person they're signing it against. Therefore, every single judge that has ever signed a removal order needs to be brought up on criminal charges of violating a person's Fourth Amendment rights. And since the case was, the entire case was fruit of the poison tree from the very first instant when the children were taken from the home, everything that happens after that should be expunged, and the children should be returned regardless of whether or not they've been adopted out to anyone else, because the state shall not benefit by breaking a person's constitutional rights, not in this country. Every judge that is sworn in swears to this oath. I, state your name, do solemnly swear or affirm that I will support and defend the Constitution of the United States and the Constitution of the State of California, or whichever state you're in, against all enemies, foreign and domestic, that I will bear true faith and allegiance to the Constitution of the United States and the Constitution of the State of California, that I take this obligation freely without any mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties upon which I am about to enter. Every judge that signs a removal order that takes children from a home without a warrant is violating that oath, because they know that they are violating a person's constitutional rights by signing a removal order that is not based on clear and convincing evidence. It is not based on an affidavit or an oath under perjury. It is a violation of their constitutional rights, and the judge knows this when they sign it, and therefore they have violated the oath that they swore to uphold when they first became a judge. I want everyone that is listening to this message who has had a child taken by the Department of Children and Family Services, CPS, or whatever you want to call it, regardless of what state they live in, they need to contact their local district attorney and tell them that they had their Fourth Amendment rights violated, because the district attorney is the only one who's authorized to bring criminal charges, and a violation of your constitutional rights is a criminal charge, even though it's kind of civil rights, but civil rights lawyers don't get to file charges against people. Only district attorneys do. So everybody needs to call their district attorney and write their district attorney, and even call and write their own state's attorney general and demand that they look into this and file charges against the judge and the social worker who arrived and took your children with a removal order. A removal order is not a warrant.